the Road Accident Fund is proposing new amendments to the Department of Transport's draft Road Accident Fund Amendment Bill. Now, according to the proposed changes, medical aid members and medical insurance holders will no longer be able to claim for medical expenses incurred. This is expected to lead to higher medical aid premiums. Well, the new rules also would require foreigners to provide proof of legal residence in the country at the time of the accident before they can make a claim. Well, let's get an understanding of how the medical schemes are digesting this, and we speak now to Discovery Health CEO, Dr. Ryan Noach. Dr. Noach, thank you very much for your time. Let's take a few steps back. Talk to us about how this process has previously worked with the Road Accident Fund for medical scheme members.
Yeah, thanks, Xoli. Thanks very much for having me. Good to be on your show again. For the past 30 years or so of Discovery Health medical schemes' existence, and for many other medical schemes across the industry, medical scheme members who are involved in a road accident fund are fully indemnified against their healthcare costs by the medical scheme. In simple language, their healthcare expenses following a road accident fund claim are paid by the medical scheme. But the medical schemes then work with the members for the members to claim directly back from the road accident fund their entitlement in terms of those healthcare expenses. And this relates to typically the healthcare expenses immediately following a traumatic road accident event. It doesn't entirely relate to the long-term disability component, which the road accident fund covers.
Yeah.
As a result, medical schemes across the industry have been able to recover. In 2022, we estimate at an industry level about R500 million or 600 million rand or so at an industry level from the Road Accident Fund. And that 600 million recovered by members, which is then passed back to the medical schemes to offset their claims payments, that effectively goes back into the members' risk pools. Schemes are like mutual funds. The money is owned by the members, and so effectively manages to reduce some of the contribution payments for scheme members. And that now appears to be proposed to be changed.
At the moment, you are waiting on a judgment from the Constitutional Court. This is against the Road Accident Fund over the reimbursement of scheme members for accident treatment. What is your argument at the Concord?
No, completely correct, Xoli. This is a long-standing litigation matter. It's a legal fight that's been going on for about 2 years now. About 2 years ago, the Road Accident Fund circulated through their acting chief operating officer at the time, someone that's since left the fund. They circulated a note to all their officers to say that medical claims from members who are also medical scheme members should immediately cease being processed. In other words, without any consultation with the industry, change to the legislation, they sent out a letter to their officers to say stop processing medical scheme members' claims. That was clearly a breach of the law. And that's been recognized by both the High Court and the Supreme Court, where the matter has been heard. And in both of those courts, it was ruled unanimously in the favor of schemes, saying that what the Road Accident Fund was doing was illegal. At a principle level, Xoli, it's not difficult to understand. You can understand medical scheme members pay the fuel levies in the fuel price the same as any other road user. They are not exempt from paying the levies which go to the Road Accident Fund. And according to the Road Accident Fund Act, as a result, they are equally entitled to claim from the Road Accident Fund. The fact that some people choose out of their disposable take-home pay after tax to take out medical insurance should not in any way be used as a form of discrimination against them, that they may not claim from the Road Accident Fund. And that's effectively what the Road Accident Fund is doing. So after losing at both the High Court and the Supreme Court of Appeal, the Road Accident Fund has now taken this on appeal to the Constitutional Court, and we are awaiting the outcome of that appeal for the appeal to be heard.
Yeah. Let's try and get into what they are suggesting is the reasoning behind these proposed amendments. So, and I'm going to put it to you in the form of a question, and it goes, why do you find issue with the proposal for limits to how much the RAF can pay for treatment? Because this is their standpoint, and that is that they argue it's a cost-saving exercise.
In the first instance, Xoli, we should not confuse the issues. They are proposing limits on their cover, but that's not the subject of this litigation, nor does it relate specifically to medical scheme members. It's a separate issue which would relate to all road accident users and how they would be reimbursed in a healthcare incident. So let's separate the issues. On the medical scheme issue, what they're doing is simply discriminatory, illegal as determined by 2 courts, and we hope that the Constitutional Court will find the same. On the tariffs issue, which is a completely separate issue, I should rush to point out that Discovery Health has not been involved in that litigation at all. There are, however, other civil society organizations that have been in litigation with the Road Accident Fund over their proposal to reduce the payments for healthcare incidents happening to road users. And that litigation was ruled against the Road Accident Fund by the High Court in this past week, wherein the High Court found it's unreasonable for the Road Accident Fund to unilaterally reduce the tariffs, the prices that they will pay for healthcare expenses for road accident users. The prices that they've proposed, you may be interested to know, are at about 60% of usual private healthcare prices. And so effectively what the Road Accident Fund is proposing is that nobody who receives a Road Accident Fund compensation claim for their healthcare expenses would effectively be able to afford private healthcare. And quite contrary to the earlier discussion, this would seem to punish the non-medical scheme members much more than the medical scheme members. Medical scheme members have cover and can afford private healthcare. The non-medical scheme members who are users of the road and incur healthcare expenses after an accident would simply not be able to access private healthcare based on this new proposal. So the courts, in separate litigation, wherein Discovery Health did not participate, they in fact ruled in favor of the complainants, the civil society organizations, against the Road Accident Fund, and said that these tariffs would be unfair and unlawful.
Final question to you, Dr. Noach. Are you encouraging your members to take part in the public comment process? Because that's how things work. For any proposed law to become law, it first has to go through the public consultation phase, because this would provide an opportunity, particularly for members of the public, to understand how these things work. Is that something that you would encourage?
Most certainly, and we certainly will exercise our right as a active citizen in South Africa to comment on the Government Gazette, which was published last week, with proposed amendments to the bill, including both of these issues that you've raised with me today, both the tariff issue and separately the medical scheme member exclusion issue. So we'll exercise our right, and I would encourage absolutely everyone to do so. And in fact, the Deputy Minister who was interviewed yesterday, the Deputy Minister of Transport himself, encouraged people right across society to please provide comment on these gazetted draft amendments. He indicated that the Department of Transport would certainly take those into account.
Well, we're certainly going to be talking to the Deputy Minister of Transport, Lisa Mangu. Let me thank you very much for your time and explanation here at Discovery Health CEO, Dr. Ryan Noach. All right.